All right, everyone, we're going to go ahead and get started here. I'm going to go through some housekeeping notes, and perhaps if other people are still logging in, this will give them a little bit of time to log in before we get into the actual slides. My name is Leila Norden, and this is the Notice of Action, or 803, and Appeals Training for Case Managers of HCDS Waivers. Before we get started, I want to just go through some items. If you've not yet done so, on the lower right-hand side of your screen, you should see a box that has files to download. In that is the presentation itself. So if you've not yet downloaded this presentation, go ahead and do so, and you'll have it available to print out. The way this training is structured, I've included information for your reference for future needs that you might encounter within your day-to-day work. In addition, all of you are on mute. We have so many participants that to enable people to speak up or ask questions would become unwieldy. So I ask that as questions arise or as issues arise, you go ahead and type those into the chat box. I won't prompt you for questions. I encourage you to type them in as they occur to you, and then when I come to good stopping points, I will go through the questions. With that in mind, I may not be able to address all questions that are brought up today. What we've experienced with previous trainings is that the questions often are far more questions are being asked than we have time for. But like previous trainings, we are compiling all of the questions asked in the various webinars and creating a frequently asked questions document. We are going to be posting a recording of this training and a copy of the slides and those frequently asked questions to the department website when we're done. This is the last webinar for this round of this particular training. Keep in mind that this presentation, this training, is a very high-level overview of the Notice of Action and Appeals process. I'm going to try to address questions that have come up in previous webinars, and as you have questions, certainly ask them, but I may not be able to address specific situations that you're encountering. It's intended to really be a high-level overview regarding the process and the requirements. All right, so with that in mind, let's go ahead and get started. The mission of the Department of Healthcare Policy and Financing is to improve healthcare access and outcomes for the people we serve while demonstrating sound stewardship of financial resources. The topics we're going to cover in this training include providing an overview of the Notice of Action and Appeals. Then I'm going to go specifically into the regulation regarding recipient appeals. So 10 CCR 2505-10, 8.057 addresses the regulations for Medicaid recipients regarding appeals. I'm then going to show screenshots from the BUF to review the process you will complete when you're completing a Notice of Action. Then I will go over an overview of that appeals process, so the life cycle of a Notice of Action through an appeal. And then at the very end, we're going to go over some specific scenarios I'm going to ask the audience whether or not you feel that a Notice of Action should be sent in those situations. Okay, so depending on how long you've been a case manager and doing this process, some of the terms or I guess just terminology regarding Notices of Action and Appeals can be very confusing. There's a lot of different terms thrown about, 803s, They're often referred to as 803s when they're notices of action. People talk about appeals and hearings, and lots of terminology is discussed. The overall point that I think is very important for case managers to take away regarding this topic in general is that individuals who are enrolled in services, who are receiving those benefits, must have the opportunity to request a hearing and to appeal adverse actions that affect their benefits. And so as case managers, your responsibility is to complete these forms accurately and appropriately for the individual so that they are given that opportunity. As I said earlier, the primary regulation we're going to be looking at today is regarding recipient appeals. And again, that's 10 CCR 2505-10, 8.057. I want to point out the importance of when you're citing regulations in your notice of action, the importance of citing it with all of that information. So when you put the regulation within a notice of action, you would not just put 8.057, for example. You would put in the full text that's needed, the 10 CCR 2505-10, and then the regulation that's applicable. In this case, we're talking about 8.057. In the next several slides, I've summarized this regulation, and I'm citing it at the bottom of every page. But please note that it is a summary, and so when you have specific questions, I encourage you to go directly to the regulation itself to review the actual wording for the regulation. Something else that case managers should be aware of. When you're citing regulations, and I'm going to, in the next few slides, talk about give you some tips to help ensure that you do cite the correct regulation. When you're citing regulations, you really need to cite the ones that are applicable to your specific situation, so the type of case management agency that you're working with or that you are with, and the appropriate waiver. And the reason for that is that appeals, when people appeal decisions or actions, the appeals can be determined based upon clerical errors. The ALJ or the administrative law judge may see in favor for the person who's appealing because of a clerical error on the part of the case manager in completing this form. And it's really important that that not be the reason, that when someone appeals a decision, they're appealing it based upon the merits of the action itself and not based upon choosing the wrong regulation to cite in the notice. So for example, single entry points have specific regulations that apply to their responsibilities as case managers from the single entry point. So that is 10 CCR 2505-10, 8.393. Case managers from community-centered boards have their regulation for their responsibilities as case managers within 10 CCR 2505-10, 8.607. So a case manager at a SEP or single entry point should not cite regulations for the CCB case management services and vice versa. There are those regulations that do apply to both case managers from SEPs and CCBs. And the best example I can give for that would be for the guidelines for long-term care services or the regulations regarding the ULTC 100.2, because that is an assessment that is completed by case managers from both types of case management agencies. And that is 10 CCR 2505-10, 8.401.1. So that's just something that I encourage case managers to be mindful of. In addition, it's very important that case managers cite the appropriate regulation for the waiver that the individual is receiving services from. This is extremely important because different waivers sometimes have services that have the same name. So for example, supported living services has personal care. The elderly, blind, disabled waiver also has personal care. However, within each waiver, what personal care looks like and the structure of personal care, how that service can be delivered is different. And so if you're sending a notice of action for someone who's on the elderly, blind, and disabled waiver, it's really important that you cite regulation from that waiver. Case managers who have caseloads for specific waivers really should familiarize themselves with these regulations for the waivers that they serve. So if you have a caseload of people who are on the CMHS waiver and the EBD waiver, I encourage you to go into the regulations and just review them and see all the information that's contained for each of those waivers. It's not required that you memorize everything, but you should be aware at the time that you're notifying people of actions that you know you have some idea of where to look, that it might be multiple regulations that you're citing in the notice of action for that one action. Another very useful link for you that'll help prevent errors is a page on the department's website. I've got the URL here listed, and on the next slide I'll show you what it looks like when you click on this URL. This should help you identify the specific regulation that you're looking for to prevent you having to go into the regulations and do a search over all of the information contained there. So when you click on this link, you'll see here, I've copied the top portion of this page. What it has is the individual department program rules and regulations. And you'll see the main heading and then subtopics for that heading. That's what I've identified with the blue squares, the blue rectangles. And when you identify which one it is that you're looking for, say for your particular waiver or type of case management agency, the box that the pink box that I've identified there is where there's a hyperlink for those actual regulations, and it'll take you into the regulations themselves for you to get the actual language that you might need to cite. So I do have a question in the chat box asking if there's a regulation citation for a nursing facility stay. Within your regulations, you may see individual information for a nursing facility stay. I'm not giving you all of the possible regulations you may cite here. I'm just giving a general idea to assist you with finding information that's applicable to you. I encourage you to go to this page on the department website and look through the different topics to identify what you're specifically looking for. Okay. So as I said, we are going to focus primarily on the regulations regarding recipient appeals. We're going to start with some of the definitions, and these are contained within the regulation itself. So action. Action is defined as a termination, suspension, or reduction of Medicaid eligibility or covered services. So when you're sending a notice of action, it is when what is happening is one of these things. It's a termination, suspension, or reduction of that individual's Medicaid eligibility or their benefits. The date of the action is the intended date on which that termination, suspension, reduction, transfer, or discharge becomes effective. So for those of you who've gone on the bus and completed a notice of action form, the effective date that you enter is that date of action. The notice itself is defined as a written statement which contains a statement of the action the department or its designee, in this case your case management agency, intends to take, the reasons for that intended action, and what the specific regulation is that supports that action, or in cases where there's a change in federal or state law, what that change is that requires the action. In addition, the notice provides an explanation of the individual's right to request a hearing if one's available, or in the cases where an action is based upon a change in the law, what are the circumstances under which a hearing will be granted. In addition, the notice provides information to the individual for the method that they can request and obtain a hearing. It also reviews that the individual may represent himself or herself or use legal counsel, a relative, a friend, or other spokesperson at the hearing. And then it also provides an explanation of the circumstances under which Medicaid benefits are continued if a hearing is requested. A request for hearing is a clear expression by the applicant or recipient of his or her authorized representative that he or she wants the opportunity to present his or her case. So the request for hearing is them stating that they want to appeal that action and they want to present their case for why they are appealing. Okay. So I just want to make a note that all of these things that we've talked about with the action and the information contained within these definitions, if you've not yet done so, I really encourage you to review the document that you are mailing to people, that notice of action itself. You will see all the information that an individual receives when you send the notice of action and all of the instructions that are contained within it. It's very helpful for case managers to have that information, particularly when you're discussing with an individual that they can expect this action to occur and that you'll be sending them a notice of action. It helps you to have that information in hand. The other thing that you need to be aware of is that there's some very specific timelines that are specified within regulation. So the notice must be mailed to the recipient at least 10 calendar days before the date of the intended action. Within the bus, when you're filling out that notice of action form and you put in the mailed date, and then the effective date must be 11 days after the mailed date, that's how we assure that you are giving the individual the 10 calendar days before the intended action. They allow for 1 day for the mailing date. There are some circumstances under which you are able to provide fewer than the 10 days, and that is detailed in 10 CCR 2505-10, 8.057.2.b, and 8.057.2.c. And those circumstances are when the individual has died, the individual no longer wishes services, the individual gives information that requires the termination or reduction of services, and the individual understands that this is the result of giving that information, or if the recipient is admitted to an institution. Please note that if an individual has died, you do not need to generate an 803 or a notice of action. Other times when the 10-day timeline for the action to occur can be different is if the individual's whereabouts are unknown and no forwarding address is available, or if the individual receives Medicaid services outside of Colorado. In addition, if the department or its designee has facts indicating probable fraud by the recipient, and if possible has verified those facts through secondary sources, notice for any action shall be sent 5 calendar days before the date of action. So the example I give for this is, let's say CDPHE goes out to do a site observation, and while there identifies probable fraud by the recipient, they may notify the department of that, and the department may notify your agency to send out a notice of action. If something like that occurs, within that situation, you may make the effective date for that action 5 calendar days from the mail date. So Jennifer asks, can you clarify that we are not supposed to send an 803 when the client dies? Previously, we were being asked to do this. So the purpose of sending a notice of action to an individual is to give them the opportunity to appeal. And if they're deceased, they're not able to do so. They're not able to receive Medicaid benefits. Pat asks, is there a workaround for the bus programming for the exceptions to the 10-day notice? The bus won't accept less than 11 days. We're going to talk about some of these errors that come up. It will allow different days, but you will be flagged. It'll have that notification. And then in some situations, it does allow it, and we can talk about what those situations are when we go through the bus screenshots. Okay, so when does an individual have the opportunity to request a hearing? So individuals have that opportunity to request a hearing when their application for services is denied or is not acted upon with reasonable promptness, or the individual requesting the hearing believes that the action that is occurring is erroneous. Please note that in the cases where the sole issue is a federal or state law that requires an automatic change adversely affecting some or all recipients, the recipient will not have the right to an opportunity for hearing in those cases. So you should know that when an individual requests a hearing, those requests are filed with the Office of Administrative Court, and they have 60 calendar days from the date of the notice of action, so from the mailed date. The requests shall be in writing and contain the individual's name, address, and state ID number, what is being appealed, and why it is being appealed. So if you look at the third page of the notice of action, that is the document that individuals can fill out to request a hearing. Please also note that if the individual makes an oral request for a hearing, either to the department or to you, the case management agency, either the department or the case management agency shall prepare a written request for the individual and have the individual sign it to submit, or provide the information to the individual on the process and have them prepare the request. So a question that came up within one of the webinars was, isn't that a conflict to have the case management agency submit the request or fill out the request for a hearing? And your role, if you are doing that for an individual, is not to come up with the language for the individual. Your role really is to transcribe for that individual what they are appealing and why they are appealing. You are assisting them with the actual act of writing it up because it must be a written request. All right, so here's where specific dates are very important for case managers to be aware of, because it really affects whether or not individuals can maintain their benefits through the appeals process. So these timelines are very definite and very important. If an individual requests a hearing before the date of the action, their services may not be reduced or terminated until the final agency decision. So what that means is, if someone requests a hearing, I'm going to give some specific dates. Let's say the effective date that you put into a notice of action is June 11th. Let's say you mailed it out on June 1st, the effective date is June 11th, and someone requests a hearing on June 7th. They are able to keep their benefits throughout the appeals process until a final agency decision is made regarding that appeal. After that effective date, after the date of the action, the only way that services can be continued for that individual or reinstated is if the request for hearing fits these criteria. So If they make a request for the hearing not more than 10 days after the effective date, so in the example I was giving, if someone makes the request within the timeline 10 days after June 11th, they have to make the request before June 21st, and the individual has to provide verification that one of these 4 scenarios is what has occurred. So either the individual's life, health, or safety will be seriously impacted by the loss of benefits, or the individual was unable to request a hearing before the date of action due to that individual's disability or employment, or the individual's caregiver or authorized representative was unable to request a hearing before the date of action due to his or her health or employment. Or lastly, if the individual did not receive the request prior to the intended action's effective date. So a question was brought up in a previous webinar about the postmark date for those notices of action, if that would be appropriate, and that would be. In the case of the 4th possible situation, if the postmark on the envelope for that notice of action is after the action date, the individual could use that as verification, confirming that they did not receive it before the date of the action. When that occurs, they're submitting that information to the administrative law judge. If the benefits have already ended, case management agencies may be notified by the administrative law judge to reinstate those benefits through the duration of the appeal. The thing that individuals need to be mindful of is if the action of the department or its designee, in this case the case management agency, is sustained by the final agency decision, recovery procedures may be instituted to recoup the cost of services received after the date of action. So for example, I had a situation where an individual did not want to continue benefits through the appeal because of concerns about this part of the process. They did not want any chance that they might be asked to pay back for benefits they received. So they chose to wait until after the effective date for that action, and then they submitted their request for hearing. They still did it within the 60-day timeline, so they were able to appeal the action, but they weren't receiving those benefits, and they were able to go through the appeals process. If an individual wants to do that, they may do so. The thing that individuals need to be aware of, and it states it clearly on the notice of action, that they cannot appeal a decision after that 60th day. I'm sorry, Jennifer, I'm not sure what I said that you say is an example of an erroneous request. Can you provide some clarification to that question? Okay. Please also note as case managers that individuals and their authorized representatives are entitled to examine complete case files and any other documents to be used at the hearing at a reasonable time before the hearing or during the hearing. So when an individual requests the hearing and appeals an action, you are required to provide an evidence packet to them, but they also are entitled to examine the case file and to make those requests to do so. So for example, if someone, it would probably be in the evidence packet, but an example would be if someone does not meet level of care for the ULTC 100.2, they can request and receive a copy of that assessment you completed so that they have all of the information available to them. Okay, so that is a broad overview of that specific regulation. There are parts of that regulation as you go through it as case managers that are specific to Medicaid eligibility, specifically financial eligibility. And I just want case managers to know that as they're going through, because this is for all Medicaid recipients. So when you're going through and citing regulations, do read the language carefully to identify that. What we're now going to talk about are the different contract specifications regarding notices of action and appeals for both the single entry points and the community-centered boards. What I'm going to do, before we do that, I want to look at Rebecca's question here. She says, if a client submits the appeal prior to the date of the action due to no physician attestation for CDOS, will the client's allocation carry over through the appeal process? Yes, so I just want to make sure I'm clarifying that you're saying prior to the date of action, you mean prior to the effective date or the 11th day, then yes, they would keep their benefits through the appeal process. Okay. So within the community-centered board contract, and this is the contract for this upcoming 2018-2019 fiscal year, there's language that addresses the appeals process and the notices of action. So within the contract, it states that the contractor, in this case the CCB, shall represent the department and defend any adverse action in accordance with the regulation we've just reviewed, 8.057, in all appeals initiated during the contract, and that the contractor shall coordinate with the department for any adverse actions that necessitate department attendance at the hearing. So what that means is you will represent the department and defend those actions, and if you require someone from the department to be there, you will coordinate and work with department staff to be in attendance. The contractor, the CCB, shall represent its actions at the administrative law judge hearings. So when you receive a notice of hearing, the expectation is that you go to the hearing or you attend the hearing when a client appeals a denial or adverse action that affects that individual's program eligibility or receipt of services. The contractor shall process appeals in accordance with schedules published by the State of Colorado Office of Administrative Courts and rules from the department. So that means that you will process those appeals within the timelines that are specified. And then this is something that I want to be very clear on. The contractor shall submit exceptions when applicable and include all relevant information. So when an individual appeals an action and you have a hearing, both sides present their evidence to the administrative law judge. The administrative law judge will make an initial decision. From that initial decision, either person or either side presenting evidence can submit exceptions to that initial decision. And so that's at the discretion of the case management agency. If you feel that, for example, you feel that the administrative law judge is misinterpreting a regulation or misunderstanding some part of the evidence, you can file an exception at your discretion to clarify that point. The purpose of submitting exceptions is not to present new evidence, it's to provide additional information to support existing evidence. In addition, you can provide at your discretion a response to an exception. So if the appellant, the person who's appealing, submits exceptions, the case management agency, if you choose, can submit responses to those exceptions. The important thing for case managers to be aware of is that you have that opportunity for a hearing that the individual requests initially, and after that, for the rest of the process, all that is done is a review of that file or of that case. So any documentation you provide with the notice of action, with your evidence, with exceptions or responses to exceptions, all of that is contained within a file that is reviewed for all of the next steps. In addition, the expectation in the contract is that the contractor shall cooperate with the Office of the State Attorney General for any case in which the Office of the State Attorney General is involved. Within the CCB contract as well, it specifies that the contractor shall abide by and perform its duties and obligations in conformity with the relevant federal law, all pertinent federal regulations, state law, rules and regulations of the Department of Healthcare Policy and Financing, and the Colorado Department of Public Health and Environment. And then it specifies this particular regulation that we've been going over, which is 8.057. The SEP contract, the single entry point contract, has slightly different language within it specified. So it talks specifically about eligibility determination, that it includes, but it is not limited to, representing the department in all appeals relevant to functional eligibility determinations. This is that level of care that we talk about from the ULTC 100.2. The contractor obligations also are specified regarding recipient appeals, again the same regulation 8.057, and that the contractor shall attend administrative law judge hearings when the contractor agency has made a denial or adverse action against a client and the client appeals that action, and that the contractor shall defend its decision as described in 8.057. In addition, the contractor, or the SEP, shall perform all eligibility determination functions for the operation of a single entry point agency in accordance with the rules and regulations as specified, but not limited to representing the department in all appeals relevant to a long-term services and supports program participation. It goes on to specify that within the case management for those waivers, the contractor shall provide Medicaid case management in accordance with the regulations for the single entry point case managers, the 10 CCR 2505-10, 8.393, and that case management services are comprehensive and shall include but not be limited to representing the department in all appeals relevant to service authorizations. It also specifies that with training for new hires, the contractor shall ensure that all case management staff receive training within 90 days after the individual's hire date, and within that, notices and appeals is one of the training subjects that must be fulfilled. The single entry point contract also states that the contractor shall represent the department and defend any adverse action in accordance with the regulation we've been reviewing, 8.057, in all appeals initiated during the contract, and that the contractor shall represent its actions at administrative law judge hearings when the client appeals a denial or adverse action affecting that individual's program eligibility or receipt of services. The contractor shall process the appeals in accordance with schedules published by the State of Colorado Office of Administrative Courts and those rules of the department, and that the contractor shall submit exceptions when applicable and include all relevant information. And again, in this case, it is when you feel that the exception is required at your, using your judgment, you would file those. And the contractor shall cooperate with the Office of the State Attorney General for any case in which it is involved. So you can see how the contract language is similar between the community-centered boards and the single entry points, but there are some differences between the two. Okay, so Jennifer has provided some clarification. I'd like to talk about this question. She states, on the slide that states that the individual has the opportunity for a hearing when the recipient requesting the hearing believes the action is erroneous. What is an example of this? So a very good example would be, let's say there is, I'm just trying to think of one that's going to fit the best thing. I mean, level of care. If they feel that at time of continued stay review, the ULTC 100.2 assessment is completed and the case manager determines that someone does not meet level of care, if the recipient feels that they're wrong, that they do meet level of care criteria, they can appeal. That's generally what it is, if they disagree with the action. Okay, so this is I'm going to go through the slides here of screenshots from the bus to walk through the process of actually completing that notice of action on the bus itself. So when you're in the bus, if you look on the left-hand side of the screen, you will see the whole menu of options for actions you can complete on the bus. LTC 803 is where you're going to complete the 803 form or the notice of action form. When you click on that, it will bring you to a screen that has these hyperlinks at the top. There's several choices here that are available to you. When you are creating a notice of action, you will click on the one on the left, which is Add 803. When you do that, you will come to this page. So it's wee teeny tiny on the screen, but when you go into the bus, you should be able to see it more clearly. What you'll see here is it has all of the different program areas on the left-hand side. On the right-hand side, it has those dates we talked about. So it has the mailed date, the effective date, which is the date of the action, and then it has the respond by date, which is the 60 days. That's the date that the individual must respond by if they're going to appeal the decision. In addition, below that, there are the two different types of notice of action you can send out. So it's very important that case managers understand there are 5 different options here, but it can only be either a denial reason, which are one of the 3 options above the line, or it's a service change, which are the 2 options below the line. But you have to pick only one of these. There have been cases where case managers have tried to choose both, and that will make an error in the bus. Here, I've blown up that section so you can see it more closely. The type of notification, as I said, is either a denial reason or a service change. That's the text in red. So the one time that you're notifying someone of an action that does not appear to be an adverse action, and the question has come up in different sessions, is when an individual is eligible to receive services. And what they are able to appeal in those situations is the date of eligibility, which is why they must be notified. In order to appeal decisions, individuals must receive a notice of action. So as I said, you would choose one of either the denial reasons or you would choose a service change. Depending on which you choose, you then will go on to pick the hyperlink on the top of the page that is applicable. So for example, if you were choosing denial reason, you would click on that link and you would get this page. And it lists various pre-populated reasons, and then it also has provides the ability for you to type in text, and then you provide the rule or rules which apply to that action. So you're citing the specific regulation that applies to this action you are completing. If you were to choose a service change, then you would click on that link at the top and it would bring this page. And this is where you would specify with text what is being changed or decreased or denied, what are those services, and what is the rule or regulation that you would cite there. And as I said earlier, you can cite multiple regulations and should cite multiple regulations when they are applicable. So for example, if someone doesn't meet level of care, that same example I used before, you would cite the regulation regarding the ULTC 100.2 level of care. And then if you look at the specific waiver that that individual is enrolled in, if it's a CSR or applying for, within the waivers themselves, there are regulations regarding eligibility for the waiver, and it'll include information about meeting level of care. So you would be able to cite both of those regulations. They're both for the same thing and the same situation. So the example I was telling you about an error, if you put in information, the bus does have the ability to catch it. So here's an example where this is an adverse notice where the mailed date is January 1st, 2018, and the effective date of that change that I've got here is December 31st, 2017, so a day before. And you see that it's saying it has to be 11 days after the mailed date, so it flagged it. Case managers need to be mindful when they get this yellow triangle with an exclamation point. You can move on and print it out still, but you need to make note of this when the error comes up to assure that you're putting in the proper dates. In addition, I did not put the 60-day, the date the client must respond by, into the box, and that's where I got that second error that states the mailed date is entered, but the respond by date is not. Please enter a respond date. In addition, if you don't have the dates calculated correctly, you will get this error. The client response date must be 60 days from the mail date. Please use the back button and fix the error before saving the record. So that's something to be aware of, that you make sure that you give them the appropriate amount of time that they're required to have. In situations where it will allow you to have an earlier effective date than the mailed date, it won't throw up an error. So the specific example is for eligibility. Obviously, you cannot notify someone that they are eligible to receive services before they're determined to be eligible. So you might mail it on January 1st, but they were determined to be eligible on December 30th. So then that will not have an error when you check off that the individual meets eligibility criteria. You see that that top option under the type of notification is chosen in this case. Okay, so before we go on to look at the notice of action itself, I just want to look at questions and see. Has the bus issue where the denial reason does not print when choosing eligible to receive services been fixed? So Jennifer, what you're referring to is that the notice of action, what it has is static information that talks about the denial reason because that's what you've chosen. That is something that the department is aware of and is looking into, and I appreciate you bringing that up because what that highlights is the importance of a conversation between the case manager and the individual. We've had occurrences, and I'm sure you've had occurrences at your case management agency, where an individual may receive this notice of action and not understand what they're receiving. And it's a legal document and it looks very formal, and if they've gone through the application process recently, they may have filled out a lot of paperwork, and they're completing the request for a hearing without recognizing that that's what they're doing. And so I encourage all case managers to have those conversations with people and letting them know that they're going to receive the notice of action, and if they want to appeal, what the process is. And that if they don't want to appeal, they can not take any action when they receive that letter. But talking them through what to expect will help mitigate some of those situations where people are requesting a hearing and they have no intention of appealing at all. So Pat asks the question, this highlights what I was talking about. If a person is in agreement with the action, for example, agrees to a reduction of services, does this constitute an adverse action and require a notice of action? The answer to that is yes. And the importance of that is really twofold. First of all, it's a requirement, it's a regulation that they be given that opportunity. But you want to keep in mind that they may not understand the full ramifications of that change until it occurs, and they should always be given the opportunity to request a hearing and appeal. However, again, have that conversation and let them know that they can disregard the opportunity if they choose not to appeal, but you must notify them. So as I said, this is the first page of the notice of action. When you go through the printing the notice of action, you'll see you'll choose print, and you'll come to each page. It's a 3-page document. You see this first page, and at the top right is the hyperlink to go next. You will click on the next to print the second page, and then you click on next to print the third page before you can exit. But you need to print out each page individually. I've highlighted this entire first page because it's all important. So again, I encourage case managers to read one of these notices of action to familiarize yourself with all of the language contained here. It's going to identify the individual's program that it refers to and specific dates for the effective date. When you type in the effective date, it'll tell them the date of the action, and it also gives them the deadline that they must meet if they are going to appeal that decision, or that action rather, I apologize. Page 2 gives them instructions on how to request a hearing and what that process is and what they can expect, and in the cases where they may feel that they are being discriminated against, it provides information to them on how they can address that. And then page 3 is the actual document that they will complete to request a hearing, and it provides the address where that request will be sent in. And again, this has all of the dates on it for the effective dates. In the document, all of the effective dates and the date that they must appeal by are contained within the notice of action. Pardon me. So before we go into the process overview, I know we had a couple of questions. Becky is saying, do we wait to send an 803 until we have received Medicaid financial approval on new clients, or do we just find them eligible based upon our assessment? So you should know that notices are sent out to individuals from multiple areas. So when an individual is applying for a waiver service with you, you're sending a notice of action when they are determined to meet your functional eligibility or level of care for the waiver. When they go through the financial eligibility part with the county notifies them of their financial eligibility, and if they do not meet financial eligibility, the county notifies them with a notice. I don't understand your question, Jennifer. Can you please provide some clarification? The question you have saying, what would be the effective date for someone who is a 300%er? You're talking about financial eligibility. You need to clarify, going back to the question I just answered of Becky's, you're stating the date that they are eligible based upon your level of care assessment for the waiver within your waiver that you're doing the functional eligibility for. Okay, we're going to go over a process overview. Just give me one moment. All right, thanks for waiting, everyone. I apologize. We had some discussion in the room. I'm going to be giving some examples. There seem to be a lot of questions regarding financial eligibility, These are going to come up in our scenarios. We've had very good conversation in previous webinars regarding what happens between financial eligibility and level of care eligibility. So we will get to that. I'm trying to provide a very broad overview here, but it'll definitely be discussed further in those scenarios. I know someone would like for us to be unmuted. Unfortunately, we simply cannot do that, and I want to be very mindful of our time. So I'm going to go ahead and go through the process overview right now, and then as we have the ability to address specific questions, we will. Okay, so I want to talk about sort of what happens within, as I said, the life cycle of a notice of action that goes through a hearing through the appeals process. So we start with a conversation between a case manager and the individual. When a case manager encounters a situation that's going to require an adverse action and is going to have to send a notice of action to the individual, the case manager will have a conversation with that individual to explain that because of either a denial or a service change, a notice of action is going to be sent out. The purpose of that conversation is twofold. There is the piece that I shared earlier about explaining the process and helping the individual understand their rights. The other part is to encourage conversation with the individual, because if the individual submits a request for hearing, you do want to know about that as a case manager, because that affects their benefits, whether or not their benefits remain in place during the appeals process. So having that conversation with an individual and encouraging them to contact you if they are going to submit a request for hearing, so that you can assure that their benefits remain in place, is helpful. After you have that conversation, you will follow up by sending that notice of action to the individual, completing it on the bus, and mailing it to that person. The individual will then hopefully notify you, the case manager, of their intent to appeal, and then follow up by submitting that request for a hearing to the Office of Administrative Courts. If by the time you reach the effective date for that action and you are not yet sure whether or not the individual intends to appeal, you can contact the Office of Administrative Courts and ask if a request has been submitted. In cases where a request for a hearing has been submitted, what happens next is that a notice of hearing is sent out. So if you look at the top left-hand part of this image, you'll see that it's the appellant versus the appellee. The case management agency is the appellee. And within the notice of hearing, there's a lot of information about the process, but there's also specific instructions for you, the appellee, within the notice of hearing. And I've popped out some text from the document that is important, so we're going to talk about that a little bit. You'll see here what I've highlighted is the portion of the notice of hearing that states you, the appellee or case management agency, are required to write a letter stating the facts of the case, the reasons for the agency's decision, and the State Department rule or rules that support that decision. With the letter, you must attach all exhibits you intend to rely upon to support your decision and include the notice of adverse action. You must mail a copy of this evidence packet to the appellant, so to the individual who's requesting the hearing, and to the administrative law judge no later than 10 days prior to the hearing. And then it provides the address. Prior to the hearing, please provide a complete copy of the notice of action being appealed for review by the administrative law judge. If a copy of the notice of action is not provided or is incomplete, any termination or reduction of benefits may be set aside by the administrative law judge. So this is very important. This explains the process you must follow when an individual appeals an action from a notice of action you've submitted or you've sent out. The notice of hearing goes on to provide more information. The piece of that notice of hearing that I think is very important for case managers to be aware of, and this highlights the importance of filling out that notice of action correctly, both with the correct dates and timelines that people should be afforded, and also the appropriate regulations, is stated here. What it says is, at the hearing, if the administrative law judge determines that the notice of action you are appealing is legally insufficient, any termination or reduction of benefits may be set aside on that basis. What that means is, if the administrative law judge makes a determination that you filled out the notice of action incorrectly, and so therefore either the regulation cited is not the correct one or an accurate one for that individual, or the time provided to the individual is not correct, then the administrative law judge may make a decision based upon that error, not based upon the merits of the action itself. It goes on to say, if the notice is legally insufficient, you, in this case, it's referring to the appellant, so the person who's appealing may waive the defense of insufficient notice and agree to proceed with the hearing on the merits. So it's saying that the person who is appealing may say to the judge, I understand that the information was filled out incorrectly, but I want you to make a decision based upon the action that they were taking, rather than on the error in the documentation. The individual may also ask the administrative law judge to decide the appeal on the basis of legally insufficient notice. So the individual also has the choice or the option to ask the administrative law judge to see the case based upon the error of the form. If they do that, then the State Department may issue legally sufficient notice in the future and may seek recoupment of benefits if a basis for denial or reduction of benefits is subsequently determined. So that means even if the form was not filled out correctly, and if the judge makes a determination based upon that error, that clerical error, a correct notice of action may be sent out and have a judge make that determination on the merits of a correctly filled out notice of action, and the costs for those services may be recouped. Okay. So going back to the process overview, as I said, the Office of Administrative Courts is going to notify the department and you, the case management agency, that an appeal has been filed when an individual submits a request for hearing. In that document, it also provides the date of the hearing and other important details. It's very important that case managers not request continuances for the hearing. We've had some occurrences where continuances were requested because the office is closed on Fridays or things like that. Individuals who are requesting a hearing based upon an adverse action should be afforded the opportunity to have their case heard. And it's very important that case managers really meet those hearing dates. At the hearing itself, each side gets to present their body of evidence, their case, and to argue their case before the judge. The administrative law judge may have questions for each side and sort of ask for clarification at that time. After the hearing, the judge takes that information that's been presented and will then go on to make an initial decision afterwards. It's not done at that time. Once that initial decision is made, whether it's the appellant or the appellee who disagrees with that initial decision, they can write and file an exception to that decision. So as I said, this can be done at the discretion of the case management agency, whether you're a single entry point or a CCB. If you feel that, you want to clarify a point from the judge's determination, you can file an exception. And as I said earlier, if an exception is filed, the other party can submit a response to those exceptions. All of that information is contained together and then submitted to the department. The department makes the final agency decision. So you should know that an initial decision may be supported by the department, or the department may actually overturn the initial decision and make a different determination. So it's very important that case management agencies and case managers wait for that final agency decision. And then we are not going to go farther into the process, but be aware that there are cases where an individual may disagree with a final agency decision, and they can take their case on further through the appeal process beyond the final agency decision. I just want to highlight what we talked about earlier regarding the timelines, because I do think that this is a very important piece that case managers need to be aware of. What I want to make sure is that the effective date or the date of the action, that case managers are aware of those when they send out a notice of action, and that depending on whether or not an individual requests the hearing, they either complete that action or they assure that that individual maintains their benefits. So going back to that example I gave earlier, where the notice of action is mailed on June 1st, the effective date would be June 11th. If you look at the left-hand side of this screen, if they submit their request prior to the 11th for a hearing, so in this case, say June 8th, then their benefits continue through the entire process until that final agency decision. If instead the benefits are discontinued or that action is completed on June 11th, if you look at the example on the right, an individual, let's say, requests the hearing after that effective date but before 10 days from that effective date, so in this case June 15th, and that individual provides evidence that they fit one of those four options. In this case, the individual may provide evidence that due to his or her disability, he or she was unable to submit the appeal prior to the date of the action and requests that those benefits be reinstated. Then the administrative law judge will inform you as a case management agency to reinstate those benefits through the duration of the appeal. Okay, we have a lot of questions I can see have been coming in, and I don't know that I'm going to get to them all. I think that's unlikely because I definitely want to make sure that we have adequate time to talk about the different scenarios. But let's see for the different questions. Okay. All right, so Jennifer is clarifying the information about a 300%er. And I'm going to take your question, Jennifer, and I think I understand. I just want to make sure. I think what you're asking me is if their financial eligibility affects their benefits, is what it looks like you're saying. Because you're saying previously if someone was a 300%er and we provided notice that was sent between the 1st and the 15th of the month, the effective date of change was the last day of the current month. If the 803 was sent out from the 15th to the end, it affects the other. So here's what I want you to take away from this, because I think what you're asking is specific to eligibility for Medicaid itself, and what you mean is financial eligibility. Case managers, and we'll go through this as we go through scenarios, but case managers need to complete a notice of action regarding the waiver benefits or the services within the individual waivers that someone is on. The county will then take that information. So let's say you send out a notice of action for an individual that they're being terminated from the waiver, as an example. Let's say the individual does not submit a request for hearing before the effective date. You will then follow up by communicating with the county that you have terminated them from the waiver. Say you'll fill out a DSS-1 and submit it to the county. The responsibility of the county is to then follow their process to determine if that individual still meets other criteria to qualify for Medicaid. It is not the responsibility of the case manager at either the single entry point or the community-centered board to make that determination. That is the county's responsibility. You need to follow the timelines that are specified in the regulations for your notices of action and for those actions to be completed. If an individual wants their benefits to continue, so Jennifer is also asking, when someone wants their benefits to continue, do they need to submit that in writing to both the courts and the case management agency, or just the case management agency? They don't need to submit a request to the case management agency. If they make their request for a hearing in time before the effective date, and they're sending that request for a hearing to the address on the request itself, which is the Office of Administrative Courts, if they send it before that effective date, their benefits automatically continue. If they make a request within 10 days after that effective date, they have to provide that verification to the Office of Administrative Courts that they meet one of those 4 options that enables them to maintain their benefits through the appeal. This is not the responsibility of the case management agency to determine. Pat is asking, will the case manager always receive a statement from the Office of Administrative Courts that services are to continue due to the appeal status? You may not receive a notice of hearing, Pat, in time to know that they've requested a hearing. That's why I encourage you to contact the Office of Administrative Courts if you're unsure whether or not someone is going to request a hearing before the effective date. They may have, let's say they've submitted the request the day before the effective date. You may not receive the notice of hearing in time, so you can contact them. Okay, so we're going to go on to some scenarios. What I would like for you to do with these scenarios is to provide your answer within the chat box. This is just an informal way for us to look at it and see and make sure everyone's on the same page. All right, so the first scenario, scenario number 1, you've just completed a revision to a service plan for an individual on your caseload, reducing homemaker services and adding personal care services. Do you send a notice of action to the individual? See, they told me it was a gimme on this side. Oh, all right, I see a no. The person who typed in a no, can you tell me why you think not? I'm just curious. Not trying to call you out there. This is an agreement made during the service plan. This is, okay, I understand that. Let me clarify. Service plan is in place, and this is a revision to the service plan. This is not a continued stay review. So this is within the time that someone has a service plan active and they want to make a change to their services. Thank you for clarifying. I appreciate that. Okay, so everyone else is saying yes. That's great. Here's a follow-up question. What are you sending a notice of action for in this case? Yay! Okay, that's wonderful. That's exactly right. So the notice of action, because services are being decreased, the notice of action is for that reduction of services, specifically homemaker. It is not for the addition of personal care, right? So in this case, because there was a reduction, you do send a notice of action, and it's specifically for homemaker. Excellent. Thank you, everyone. All right, now that we're warmed up, let's go to scenario 2. In completing a continued stay review, or CSR, you send a PMIP form, or a professional medical information page, to the individual's doctor to complete and return. The doctor notifies you that she has not seen the individual in 15 months and will not complete the form. You inform the individual and explain that the PMIP is required for services to continue. He tells you he refuses to see his doctor. Do you send a notice of action to the individual? Paula, I'll get to your question. I see it. Okay. Everyone agrees. We need to send a notice of action to the individual. Oh, did someone lose audio? I think it's just you. No one else is specifying. Ah, great. Layla's got a point here that we're going to want to talk about. Okay. So the answer is yes. You are correct. That's excellent. All of you who typed in yes. My follow-up question to that is, when do you send a notice of action? And while you're answering that, I would like to share with you one of my favorite answers that was brought up in my last training, which was, no, you would try to help him find a better doctor, which was a lovely response, a very good case management, person-centered response. Wonderful. Excellent. Everyone's on board. So depending on when you complete that continued stay review, it could be quite some time before the end of the certification period. You would wait for the effective date. You would send the notice of action the 11 days before the end of that certification period. If the individual continues to refuse to see a doctor and you're unable to obtain a professional medical information page. Okay. We had some questions that I said I wanted to touch on. Oh, Paula asked, just to clarify, we do not need to send an 803 if we are adding services. So that's right. And I know that that's maybe different than what some people have thought in the past, but that's what we addressed with those definitions in the beginning with the adverse action and what is specifically defined as that adverse action. So the question comes up about, wouldn't this be an advisement letter because it isn't appealable? So advisement letters, and this has been something we've discussed quite in depth in previous webinars, so I appreciate you bringing this up. Thank you. Advisement letters are no longer within regulation, and in fact have not been in regulation for about a year, and should not be used. So we can talk a little bit about that and what that looks like. Advisement letters, for all of the people who are participating in this webinar, that's something that was being used by the single entry point case managers, not the community-centered board case managers. And the issue with advisement letters is that they are not appealable. In the case of this situation where an individual could appeal this decision, you need to provide that individual with their opportunity to appeal. So Jennifer says, and therefore no 803 for being put on the wait list either. Yes, you absolutely should send a notice of action if an individual is being placed on a waiting list. Currently, the only waiver that has a waiting list is the DD waiver, and in fact, it is one of the choices. If you look at the denial type of notification denial reason, it specifically states eligible to receive services wait list. And an individual does have the opportunity to appeal that and should be given that opportunity. So I believe we asked this before, but I do want to make sure that people are absolutely clear on this. Even if an individual makes a request for a reduction or termination, they must be given the opportunity to appeal if they decide that they want to do so. So even if it's been made as a request, you must send a notice of action always. Again, the conversation is very helpful to have with them, explaining their rights and that they can disregard the notice if they choose not to appeal, but you must give them that opportunity. And I want you to think about what would happen in these cases if someone, let's just say, tells you that they want a reduction of services or termination, and then you don't send them the notice of action. If they change their mind, what happens then? You must provide them with that opportunity so that they can appeal if they change their mind. Yes, Derek asks, are you saying advisement letters are no longer being used? Yes, advisement letters are no longer to be used. They are no longer in regulation. And this is something that was communicated last year to various case management agencies. But I've learned within these webinars that in some cases they are still being used and they should not be. And in fact, the advisement letters themselves may go away from the bus itself in the future. There are some specific requirements for case managers to provide notification to individuals, case managers from the single entry point to individuals, but it's not the advisement letter. You can notify in other ways, and I encourage case management agencies to determine what is the method that they will use to notify individuals of some of these actions. For example, the expectation that case managers at single entry points will notify an individual when they're told that that individual does not meet financial eligibility for Medicaid. Even if a client or an individual signed a voluntary withdrawal letter, you must provide a notice of action. Okay. Let's go on to the next scenario. I just want to make sure, because the last one has generated quite a bit of discussion, and I see we're right at 4 o'clock. So I want to make sure we go through the other scenarios, and let's see if we're able to get to other questions, we will. Okay, so scenario number 3. You complete the intake process for an individual and determine that he meets level of care for the waiver. However, after submitting the certification pages to the county long-term care office, you are informed that he does not meet financial criteria for Medicaid. Do you send a notice of action to that individual? And this is in line with the questions that we've been going over. So let me know. Okay, for those of you who are typing yes, I appreciate that. This is a little bit of a trick question. Actually, for both of you, those of you who are saying yes and those of you who are saying no. For yes, let's start with yes. Those of you who have said yes, please tell us for what action are you sending a notice of action? Aha, yay, thank you. That's excellent. So when you do the intake process for the individual and you determine that they meet level of care for the waiver, you are sending them a notice of action that they are eligible for the waiver. For those of you who typed no, can you provide to me the reason why you typed no, what you're thinking of? Thank you. Very beautifully worded. the financial department or the county long-term care department submits their own denial decision paperwork. That is correct. If an individual meets criteria for the waiver, you are sending them a notice of action that they are eligible to receive services. If, as they go through the process, they do not meet financial eligibility, they will get their own notice of action from the county office that they don't meet financial eligibility for Medicaid. And they can appeal that decision. That's wonderful. Thank you very much for that clarification. You all have a very good understanding of this, and I appreciate the time you've taken to answer that scenario. Okay, scenario number 4. An individual on your caseload is moving to another county and will therefore be in another case management agency's catchment area. You are transferring the case from your agency and asking the other case management agency to accept the case. Do you send a notice of action to that individual? Wonderful. Oh, this is great. Everyone's agreeing. That's right, because there's no adverse action. All that's happening is the individual is transferring and changing who their case management agency is. So that's very important to keep in mind. There's no adverse action in these cases. If, when an individual transfers to a new case management agency, if there are any changes to that individual's services at the new case management agency, they may have a notice of action sent out to them based upon those changes, depending on what they are. But the transfer itself, there is no need for a notice of action at all. So Jennifer is asking a question, going back to the financial eligibility question, saying, does the county send a notice of the financial denial by the county in writing to the case management agency? Case management agencies and county offices, the county long-term care techs, typically communicate via the DSS-1. So depending, I know every county is different, and communication between every county is different, but they should be getting that communication through a DSS-1. In the case of an intake that we talked about, or just even in any other situations, and we'll talk about it a little bit more with the next scenario, you can identify whether or not an individual is meets criteria for that waiver according to CBMS, which is the system that the county uses on the bridge. So that's where you may see that they are approved for that waiver for the certification span period for your ULTC 100.2 that you completed. If they meet financial eligibility, you will see that they meet that criteria, all of the criteria, by them having that eligibility on the bridge. All right. Scenario number 5, and this is the one that has generated the most conversation in previous sessions. Several months into a service plan year, you are notified that there is a break in the individual's Medicaid eligibility. So I just want to make sure it's very clear. They have a service plan, it's within their certification period, and you're notified that their Medicaid eligibility has had a break within that time. Do you send a notice of action to the individual? Put it on hold. Oh, can you clarify, Rebecca? Okay, so this scenario has generated the most confusion and questions. And I think it's because there's a distinction in people's minds between a system error, like if there's some systems issue that is making it appear that someone is not eligible for Medicaid and someone actually not being eligible. So I appreciate all of you providing your answers and your feedback about the processes you've put in place or things like that, because we want to make sure that we're very clear on this. So in the case, within this scenario, what I want to talk about first is, let's say someone is enrolled in a waiver and they meet all of the criteria, targeting criteria, level of care, and financial eligibility at the time that that service plan is completed. They are enrolled in the waiver and all is good. Within that certification span period, let's say they inherit a lot of money or get a raise at their job, and then suddenly they don't meet financial eligibility. In those cases, they will receive a notice of action from the county that they are no longer financially eligible for Medicaid, and they can appeal that. And as a result, they will no longer be eligible for the waiver because they don't meet all of the necessary criteria to be eligible for the waiver. And you as case managers should send a notice of action giving them the appropriate timeline to appeal as soon as you are made aware of that break. So you will have the mailed date and the effective date 11 days after with that full time. So what would be the rule used? Oh, I'm not, sorry, I thought you were asking something else. I won't address that question yet. Okay, so that's one scenario. When I presented this training the other day, some case management agency staff were talking about processes that they've put in place because of issues with systems. And I recognize that there's some issues and confusion regarding CVMS data feeding into the bridge. That's not what I'm trying to address with this scenario. What I'm trying to address with this scenario is when someone might have their RRR due within the certification span period. That RRR is a requirement by the county office to be redetermined for their eligibility for Medicaid, and the timelines for that don't sync up with the timelines for your certification span dates for the waiver. So if someone is notified by the county that that eligibility process is due and they don't either follow up with the appropriate documentation, or if it's determined that they no longer meet Medicaid eligibility criteria for financial eligibility, then you will have to notify them that they will have their waiver services terminated. And they can appeal that decision. And they should appeal the decision for financial eligibility. Now, something I want to highlight that's relatively new to the recipient appeals regulation, and it's not contained within this training because it's only applicable to financial eligibility, is there's a new process that's specified in those regulations regarding the informal dispute resolution when financial eligibility, when an individual has been determined to not be financially eligible for Medicaid. So you can have that information and provide that information to individuals that they can appeal that denial of financial eligibility for Medicaid, and that they can request the informal dispute resolution process with the county to try to resolve whatever issue it is that is making them not eligible. Perhaps they need to just provide some documentation that will enable them to have their Medicaid reinstated. So I just wanted to talk that through and make sure that case managers are aware of that if they have a break in their Medicaid eligibility, they will therefore need to be notified as well about the waiver termination as well, and you do need to send a notice of action. Before I get to questions, I do want to see, I just want to go over some information here, and then if we have some time for questions, we'll go over that. But I do want to give you, go over a quick summary from this training to make sure that we're clear on what's important for you to take away from this, and then I want to give you some contact information for questions that may arise in your day-to-day work. Okay. So just to ensure that that it's clear, when an individual has a termination, suspension, or reduction of Medicaid eligibility or their covered services, they must be given the opportunity to appeal that action. So case managers, as a result, must provide a notice of that action, informing individuals of the action that is to occur, and to provide them with the opportunity to request a hearing and appeal that action. When they send the notice of action, case managers must cite correct regulations in the notice of action itself, and they must enter the correct dates in the notice of action to ensure accuracy and that people are afforded what they, the full information and timelines they are entitled to within the appeals process. I want to talk about the contact information I have contained in this training. So any questions that you may have regarding appeals that have to do with regulation or policy or process, those questions should be directed to Victor Robertson here at the department. He's the case management specialist here. Joelle Morrison also works at the department, and she is very kindly offered to have her contact information included in this training, but she works specifically with eligibility appeals regarding financial eligibility. So if you have a question that is specific to someone on your caseload or someone you are working with who's appealing financial eligibility and you're looking for answers to those questions, Joelle has offered to have her contact information included here for you to address those questions to her directly. Really, all other questions regarding appeals should be directed to Victor. Okay. Pardon me. So it looks as though we have some time. We have quite a few questions that have come in. I'm going to see which ones I can address. I'm going to try to choose questions that are specific or applicable to the majority of participants in this webinar. As I said, thank you for typing in your questions. Even if I don't get to them today, please keep typing them in because I compile all of these questions later to review and include within the frequently asked questions as best I can. I compile them together. Okay, so Rebecca's asking a question about when the long-term care office, when it's determined that someone does not meet criteria for financial eligibility, I am saying yes. She's saying, are you still saying we need to send an 803? The answer is yes, but what you are sending the 803 for, the adverse action that you are notifying them of is the loss of their waiver benefits. So you need to provide them with that. I really encourage case managers to think in terms of the adverse action that is occurring within the scope of your work with that individual. So because they lost their financial eligibility and therefore had a break in their Medicaid eligibility, they will then no longer meet eligibility for the waiver. If you look at the individual waivers you serve, you'll see under application and eligibility for the waivers, it specifies that they must meet financial eligibility criteria. So that would be the one of the regulations you could cite in that notice of action for the loss of waiver benefits. Okay, so I'm seeing a lot of questions here. Just to quickly try to consolidate some of the questions. I'm seeing a lot of questions that are asking for what regulation will be cited in a particular situation, or what do we state when we're notifying them. So I want to be very, very clear here. I have specified some regulations within this training that will be ones that you as case managers will commonly use, specifically those for waivers or those that have case management agency specific requirements, or the ULTC 100.2 is an assessment completed by all case managers, and so on. However, I have not included all of the applicable regulations that might possibly be cited by a case manager within a notice of action. There's no way for me to account for all potential eventual reasons why you might submit a notice of action or send a notice of action to an individual for an adverse action. This is why I encourage you to familiarize yourself with those regulations that are most applicable to you as a case manager. So depending on which type of agency you are a case manager for, I encourage you to look at those regulations. Depending on which waivers you support on your caseload, I encourage you to familiarize yourself with those regulations. And then know that as you are sending out notice of actions, I didn't address it specifically, but on the page that talks about the signature for the case manager and the case manager's supervisor to sign that, that's a good checks and balance as well. Supervisors really need to review those regulations that are being cited and be familiar with the regulations to assist case managers with ensuring that the correct regulations are cited for that specific scenario before it is mailed out. That's why the document is set up the way it is, to have that checks and balance. So Jennifer asks a question that I think kind of addresses multiple other questions that are being asked. So I just want to make sure I'm going to clarify. She states, during initial enrollment, we send an 803 only for the initial level of care eligibility, not for financial ineligibility. However, once in a waiver, we do send an 803 for financial eligibility and therefore waiver eligibility. All right, so let's start with the first part of your question. During an initial enrollment, you do send an 803 for level of care eligibility. You are notifying them that they are eligible to receive services. And that is correct. You do not send an 803 when they are determined to be financially ineligible or not financially eligible for Medicaid. Then the second part of your question, once in a waiver, we do send an 803 for financial eligibility and therefore waiver eligibility. You are never sending an 803 for financial eligibility. Whenever you send an 803, it is regarding the waiver benefits that you are supporting as a case manager. However, if financial eligibility has a negative impact or causes an adverse action for the waiver services, that's where you're sending an 803. So Becky makes a note saying that there's no rules to specify a client's requesting reduction nor financial ineligibility. I encourage you to look at the regulations. There are, in fact, regulations that you can cite in those specific situations. And this is why I'm encouraging case managers to really familiarize yourself with the regulations that are applicable to your specific caseloads. Okay, I'm going to review some of the questions that have come in. We have only a few more minutes left. I appreciate, again, all of the questions and the feedback you are providing. And as I'm reviewing this, I do want to say in general as well that in previous trainings, quite a bit of feedback has been provided or information has been provided. And I want to thank you for your continuing to do that. You may have noticed that even if at the time of a training we're not able to address certain situations or certain questions that come up, I hope that you are aware that the department does hear you and certain changes do occur based upon feedback provided by case managers during training. The specific example I could think of is from when we had the ULTC 100.2 training, and there was quite a bit of discussion regarding information in the hyperlinks not being consistent with the scoring criteria. And I hope you've noticed that we have been able to have those hyperlinks removed. So things like that are very helpful, and again, I do appreciate your feedback. So don't, please continue. It's very useful, and it is read. Okay. Let me see. Oh my goodness, we have some quite lengthy questions. Let me see if I can get to one before we run out of time. Jessica, thank you very much. I really appreciate you citing that regulation and providing that information. Thank you very much. This is exactly what I'm asking case managers to do, to be familiar with the different regulations and be able to navigate that information. So thank you. That's great. So another thing, just real quick, one other thing that came up yesterday, and I think it lends itself a little bit to the question about utilization. When you are monitoring your caseload and providing monitoring to individual cases, this is another opportunity. I know there have been some questions that came up earlier or statements saying that you're not being notified by the county when Medicaid eligibility has a break. That is another point that has been brought up in previous trainings. But when you're going into the bridge and doing that monitoring to review utilization for an individual's PAR or the line items on their prior authorization, I encourage you to look at their Medicaid eligibility at that time. That's your opportunity to see if there's been a break in their Medicaid eligibility and to address the situation as promptly as you can when you identify it. I do know that there are, unfortunately, sometimes that information is not being communicated as effectively as we would like between the county and case management agencies. But this is really your chance to see the real-time data that is in CBMS. It's contained within the bridge. It's also something that within your monitoring will enable you to look at the utilization of services for an individual when you're monitoring your caseload. So Kendall has a question saying, our county does not always remember the financial criteria for our waiver. How would we go about notifying the family or DHS about waiver rules? For example, children on Children's HCBS cannot be SSI eligible, but DHS may not remember this regulation. I'm not sure I know where the question is here. So here's the thing. The way Medicaid eligibility works within CBMS is that it really follows a process. So if someone meets criteria in one area, then they would get that type of Medicaid eligibility. But I'm not sure that notifying the county of waiver financial criteria is significant. I'm not really sure how to answer that, Kendall. Can you provide some clarification? Are you saying that if a child has SSI, you may not be aware of that when you're doing the level of care assessments for that child? And so then the county is making them eligible for the waiver even if they receive SSI? Let's see. Thank you for typing an answer. Yes, that has happened to us before. Oh. So that's very tricky because part of the financial eligibility piece is that the individual or the individual's family must identify all sources, all of their financial documentation. So what that tells me is that it's not necessarily that they're not aware of the waiver rules. I don't know. You know what? I'm going to have to take that question back and do some questioning and see. It could be any number of things. Let me take that question back. That's the first time I've been asked that. So I will talk with the benefit specialist for that waiver and financial eligibility and see if I can get an answer. And again, I definitely will want to address this within FAQs. All right, we are at time. Everyone, thank you very much for the time you've taken to join this call. And please do not hesitate to send any follow-up questions that you may have had as well. And keep an eye out for the posting of the webinar, slides and recording, and those frequently asked questions. Have a great afternoon, everyone. Thank you.